The broadcast is now starting. All attendees are in listen-only mode.
Welcome to a webinar brought to you by the American Bankruptcy Institute. I am Bill Rochelle, ABI's columnist and editor-at-large. Our assignment today is to discuss the decision handed down by the U.S. Supreme Court on May the 15th in a case entitled Midland Funding LLC versus Johnson. This 5-3 decision had a majority opinion written by Justice Stephen Breyer with a dissenting opinion written by Justice Sonia Sotomayor. Her opinion was joined in dissent by Justices Ginsburg and Kagan. Our panelists to discuss this very important case involving the Federal Fair Debt Collection Practices Act include Craig Goldblatt from WilmerHale in Washington, D.C. Craig is a bankruptcy litigator who's on the firm's management committee. He got his undergraduate degree from Georgetown with a law degree from the University of Chicago School of Law. Craig clerked for Justice David Souter on the Supreme Court and Circuit Judge Richard Cudahy on the Seventh Circuit. Our other panelist is Thad Bartholow from Kellett and Bartholow in Dallas. Thad is a consumer lawyer. He studied undergrad at University of Texas at Austin and got his JD from the Benjamin Cardozo School of Law. And I must add that both Craig and Thad are actively litigating cases under the FDCPA. Before we get into what the Supreme Court said in its opinion in Midland Funding, let me tell you how it got there. Midland Funding purchased claims where collection is barred by the statute of limitations. In other words, sale claims. They filed a claim in a debtor's Chapter 13 case. The debtor objected, and that claim was disallowed. The debtor then filed suit in federal district court in Alabama under the FDCPA. The district judge dismissed the suit, saying that the FDCPA did not apply. The 11th Circuit reversed in May of 2016. And that was important because under the FDCPA, a plaintiff who wins is automatically entitled to recover attorney's fees plus up to $1,000 in statutory damages, even if the debtor is unable otherwise to prove actual damages. The Supreme Court granted certiorari to resolve a split of circuits and, as we have indicated, reversed. Before we get into the case itself, I think I should mention that the 11th Circuit had a prior very important decision on the FDCPA in a case called Crawford. In that case, the 11th Circuit made it crystal clear that that circuit was hell-bent on eradicating the business practice, as it was in this case, where people purchase time-barred claims, file proofs of claim in bankruptcy, knowing that in a certain percentage of cases, the trustees or debtors will be inattentive, the claims will be allowed, and they will receive distributions, although they could not sue on those claims outside of bankruptcy. By statistical analysis, you can figure out what it takes for this business practice to generate a profit. And that is the business that the 11th Circuit was trying to stamp out, but perhaps failed because they were reversed by the Supreme Court. Thad, first, I would like for you to summarize for us what the holding of the majority is in the Midland Funding case.
Thank you, Bill, and thank you to the ABI for giving me this opportunity to be here today. So in the Midland Funding case, there were two questions presented to the Supreme Court. First, whether the filing of an accurate proof of claim for an unextinguished, meaning it was the debt continued to exist but was subject to an affirmative defense that the statute of limitations had run. So filing an accurate proof of claim for such a debt in the bankruptcy proceeding violates the FDCPA, or Fair Debt Collection Practices Act. And then second, whether the bankruptcy code, which governs the filing of proofs of claims in bankruptcy, precludes application of the Fair Debt Collection Practices Act to the filing of proofs of claim for time-barred debt. In my view, the holding of this case answers question number one, but leaves open question number two, and that view is made explicit by Justice Sonia Sotomayor in her dissenting opinion, and the issue in question number two really isn't addressed. However, with respect to the first issue, Justice Breyer's opinion holds that filing an accurate proof of claim on a time-barred debt does not violate the Fair Debt Collection Practices Act's prohibitions against, one, the use of false, deceptive, or misleading statements or means to collect a debt, nor does it violate, secondly, the Fair Debt Collection Practices Act's prohibitions against the use of unfair or unconscionable means to collect a debt.
Okay, Thad, if I understand you correctly, in other words, the Supreme Court did not rule whether the bankruptcy code, which was enacted after the FDCPA, impliedly repealed part of the FDCPA. Is that accurate?
That's certainly my reading of this opinion, and it's certainly a point that Justice Sotomayor makes emphatically in her dissent, is that issue is not resolved by this opinion.
Okay. All right. So in other words, perhaps implied repeal is still on the table. Craig, I'd like to go to you next. Could you please walk us through the rationale of the majority leading to the conclusion that there was no violation of the FDCPA?
Sure, I'm happy to do that. And I should say, Bill, you correctly noted that, we're involved in some litigation raising issues like these. I should say at the outset that, and I really do appreciate, like that said, the opportunity to participate. That said, the views that you'll hear from me on this call are just mine, and no one else, especially our clients, shouldn't be tagged with those views. So, but to turn to
briefly, this is Thad Bartholow, and same goes for me. Go ahead. Sorry.
So here's the court's analysis by my lights, and it is true that the questions presented were two. One, should you construe the FDCPA to cover the claims filing practice in bankruptcy? And two, if you construe it to cover the claims filing practices in bankruptcy, does the bankruptcy code supersede it? And the answer, because, at least by my lights, because the answer to the first question was yes, the second question is essentially overtaken by events. So I respectfully disagree with you that remains a live question. That question only would arise if the answer to question one were it covers it, and because the answer to the question one was it does not, you therefore have no occasion to think about question two. And as to the rationale for question one, Justice Breyer's opinion has a few different sort of strands to it. One strand goes as follows. It says, look, it is true that in outside of bankruptcy, if an individual, if a creditor files a lawsuit against an individual debtor who on a claim that is time barred and does so knowingly, that the lower courts that have considered that question have concluded that that action violates the FDCPA. And as Justice Breyer explains it, the reasons why the courts have reached that conclusion is that there's a concern that an individual, typically, who's sued as a defendant, therefore probably doesn't have counsel, will be intimidated by the filing of a lawsuit and the service of process and the initiation of a formal legal proceeding, and might, out of fear of either the expense or just the process of being a defendant in a lawsuit might respond to that by filing a check, by just sending a check to the plaintiff rather than deal with the litigation, and that that was viewed as an unfair debt collection practice. And Justice Breyer distinguishes that reasoning from the Chapter 13 context, in which there are a number of very important distinctions. One, this is a proceeding initiated by the debtor. The debtor voluntarily came into Chapter 13 and filed a bankruptcy petition and invoked the court process himself or herself. Two, there's a trustee appointed in every Chapter 13 case who is there and has a statutory duty to look at whether claims are valid or not. And three, because of other features of bankruptcy, such as the automatic stay, a consumer debtor will understand that when someone files a proof of claim, you don't respond to a proof of claim by sending a check. And so because none of the reasons why courts have found the FDCPA to apply to ordinary state court litigation are applicable in the Chapter 13 context, he said that, these are my words, not his, but essentially using the FDCPA to deal with this bankruptcy problem is like trying to fit a square peg in a round hole. And so that's one important strand, and I think probably the core of the rationale. But in addition, there's this other explanation, which is also an important part of the court's reasoning, in which he says, look, these proofs of claim are accurate and they're truthful, and they disclose all of the information that you need to know to understand whether the claim is time barred, and there's therefore nothing false and misleading about it. And moreover, in our system, when there's an important distinction between the elements of a creditor's prima facie case for the claim and any affirmative defense that might be available to the claim. And whether or not there's a valid affirmative defense relates to the enforceability of the claim and the allowance of the claim, not to the existence of a claim. And the Bankruptcy Code contemplates people will file claims. And moreover, the creditor or the claimant, when they file a proof of claim, what they are saying is they believe they've got a basis to show that they can make out their prima facie case. And as to any affirmative defense, all you say by asserting the claim is, I can make out my prima facie case, and if I do, the ball is in your court, trustee or debtor or whoever wants to object, for you to plead and or prove the availability of the defense. And you're not making any implied representation that there is or isn't a good affirmative defense, so therefore there's nothing misleading about filing the proof of claim, even if there may well be a valid affirmative defense. So that, I think, is the nub of his reasoning.
I think it's very well said, Craig. I thank you. Listen, I want to ask either or both of you if there are any implications in this decision about the opinions where circuit courts so far uniformly have held, as you said, Craig, that if you file an ordinary lawsuit on a sale debt, that is a violation of the FDCPA. Do either of you see anything in this opinion in Midland to suggest that were the Supreme Court to get a case involving an ordinary lawsuit, that they might hold similarly that there is no FDCPA violation?
Well, Bill, I would say I think that the lengths that Justice Breyer went to identify the supposedly unique features of bankruptcy and the supposed additional protections that the bankruptcy process provides to consumer debtors, which incidentally I very much feel are, with complete respect to Justice Breyer, out of touch with the reality of how bankruptcy works. But I think that to the extent that Justice Breyer's opinion really focuses on those protections and those differences, certainly they haven't, they made clear they were not opining on the subject, but to the extent those differences are absent, I can see very little reason why the court would, want to reverse the circuit courts that have uniformly held that state court or debt collection lawsuits outside of bankruptcy do violate the FDCPA.
So, Bill, this is Craig. I incline to think that is right about that. So one could, if one wanted to be, pointy-headed, say that the point that the court majority makes about the burden-shifting mechanism, that in our system, plaintiff has the burden, they are saying only that they've met the burden, the ball is then in the court of the defendant, and as long as what the plaintiff says is true and accurate, not misleading, moving the ball to the defendant to assert a defense or not is what our system contemplates, and that's not a false or misleading practice. You could take that out of context and say that, therefore, filing a lawsuit against a defendant in state court doesn't violate the FDCPA. And it's true the Supreme Court hasn't reached the question in the past. All you have are lower court decisions, and there is that language in the Supreme Court opinion. So I understand the basis for the question, though I think analytically that is probably right in saying, that the court acknowledged the thus far uniform rule that says, but there are reasons why, despite that, we think this can be intimidating and an inappropriate practice when the consumer is, an unrepresented, arguably unsophisticated party who was intended to be protected by the FDCPA. And so, as Justice Breyer explains, on behalf of the court majority, most of the trade associations have said, as a matter of best practices, that that's not a preferred or appropriate practice. And so it would surprise me if in the real world anyone read this opinion and said, now I've got a great idea, let me file a bunch of lawsuits in state court against people on debt that I know to be time barred.
Yeah. Well, listen, I have another question for the both of you, trying to define some of the implications of this case. As I said at the outset, the 11th Circuit appeared to want to kill off this business altogether. I'm wondering if you think, in light of this opinion, whether bankruptcy courts, perhaps importuned by the U.S. trustees or by case trustees, might try to use Rule 11 or other sanctions available to them to try to stop claim purchasers from filing claims based on stale debt.
Well, I know that we're seeing that already in the lawsuits that have been filed by the United States Trustee's Office, which is a division of the Department of Justice that's sort of the bankruptcy watchdog, in which they have sued various debt buyers to invoke Rule 11, which is the rule against improper conduct, as well as Section 105A of the Bankruptcy Code, which permits the court to issue any order, process, or judgment necessary or appropriate to carry out the provisions of the code. And so we are seeing some enforcement on that level. I don't know that many of those cases have reached resolution, although there is reference to a couple of cases in Justice Breyer's opinion. But I think that does point to one of the potential sea changes that this ruling could represent. Earlier, Craig was talking about there being a hole that needed to be filled with either a square or a round peg. And while I'm not going to necessarily concede the shape of the hole, I will absolutely agree that this opinion blows a hole wide open for debt buyers to use the bankruptcy process in a completely unique way and then place the burden on the the Chapter 13 trustees, who have some statutory obligation already to review and object to claims, and then also on debtors, and from a place that is much nearer and dearer to my heart, debtors' counsel, who could be exposed potentially to malpractice liability if they fail to identify and object to these time-barred and unenforceable claims. So I think that the world is very different now that this opinion has come down for the Chapter 13 trustees and for debtors and debtors' counsel everywhere. They've certainly got to be on their toes, and unless there is some enforcement action taken, I see no reason why the debt buying industry won't, how old is too old of a debt? 20 years, 30 years, 40 years, 50 years, we could see some very old debts reappearing for people in bankruptcy, and that scares me.
So, Bill, this is Craig. Just to go back to your question, it is true that there have been some number of cases in which Rule 11 sanctions or Rule 9011 in bankruptcy sanctions have been sought against those who file proofs of claim for debt that is subject to a valid statute of limitations defense. Even before this decision, as the decision itself describes, the overwhelming majority of those cases has said this is not a sanctionable activity, that if the claim is invalid, it's subject to disallowance, but it's not sanctionable. And I think the rationale of this decision really ought to be the death knell for the claim of sanctions, because when you think about what Rule 11 is saying, or Rule 9011 is, it's saying that when you file, you are making an attestation that after reasonable investigation, the facts and law support your claim. And the better way to read the rule, even before this decision, was by your claim, it means your prima facie case, that you can meet all of the elements of your claim. And you should, and even without this decision, I wouldn't have thought one would read 9011 to say, I've also investigated whether the defendant can successfully assert and plead and prove an affirmative defense, and I've concluded that they will be unable to do so. And I think the strand of this opinion that I described earlier, that basically says, and again, these are my words, not the court's, that by coming in and making out a prima facie case, all you're saying is defendant or trustee or debtor, the ball is in your court, that reasoning basically means you're not making any representation about affirmative defenses when you file, and so therefore none of those representations ought to be false or the basis for sanctions. So I do think the reasoning of this decision ought to be the death knell to those cases in which people seek Rule 11 sanctions against those who file proofs of claim as to which there's a valid statute of limitations defense.
And perhaps not surprisingly, if I may, Bill, I'd like to speak to that, because I think one of the facts that's really absent from this case is the allegation. There was no allegation made at the pleading level that Midland actually knew that the debt it was seeking to collect was time-barred at the time that it filed the claim. The allegation is that the information they provided indicated that the debt was beyond the statute of limitations, and that's, I think, an important distinction, because what Craig is suggesting is that debt collectors, which are singled out in the Fair Debt Collection Practices Act as a very special class of market participants who are subject to higher scrutiny and higher duties than average regular old creditors, are supposed to take more care than your average creditor. So if, for example, mom and pop had a debt that was beyond the were owed a debt that was beyond the applicable statute of limitations and filed a proof of claim on it, that's probably not a sanctionable practice. But here, where we actually know that Midland and its industry colleagues in fact are aware that the debts that they're seeking to collect through these claims are out of statute, or likely out of statute in any event, I think that because they're debt collectors, one of the areas this opinion most misses the mark is in conflating the concept of all creditors with the specific heightened requirements applicable to debt collectors under the Fair Debt Collection Practices Act.
But Thad,
Okay.
I'm sorry, Bill. Go ahead.
Well, let's tell you what. Let's let it leave it here on that question, and that is, there seems to be a difference of opinion on that particular question about whether courts might be able to this out under Rule 11 or otherwise. But listen here, I have a question for you, based in part on a question submitted by our audience. In 48 of our 50 states, the expiration of the statute of limitations does not extinguish the debt. It merely gives rise to an affirmative defense, and indeed a debtor can revivify that debt if the debtor makes a mistake. Mississippi and Wisconsin, on the other hand, once the statute expires, the debt is extinguished. Now, I would like to know if either of you or both of you could quickly indicate whether you think the result in the Supreme Court would have been different had this case come from Mississippi or Wisconsin, where debts of this type are in fact extinguished.
I think it would have to be, Bill. And the reason why it would have to be different is because of the emphasis that Justice Breyer puts on the definition of claim in determining whether or not the representations being made are or are not false, deceptive, or misleading for purposes of the Fair Debt Collection Practices Act. Whereas a debt that is subject to an affirmative defense still exists, and thus the representation made in the claim that the debt exists and that even if it's expired is not a false representation. However, filing a claim based on an extinguished debt that is legally not in existence for any moral or other purpose is a false representation, period, end of story. So I can, under the rationale of this case, I can't see how it wouldn't be a violation of 1692E of the Fair Debt Collection Practices Act prohibiting false, deceptive, or misleading communications.
So,
all right, well, maybe somebody... Craig, you had a comment?
Yeah, I mean, just to take the other side of that for a second, it is true there's a difference. And if the statement that you can make out the prima facie case is incorrect, unlike the case that was at issue, that makes the case different from the case that was decided. There is nevertheless a basis for reaching the same conclusion that can be found in the decision, which is, in bankruptcy, the claims process is by design is intended to reach out to, cover and to bring within its ambit any claims that could conceivably be brought against the estate, and it sets up a specific process that is designed to ferret out invalid claims. And all of the points that the opinion makes about, well, look, this is a proceeding that's initiated by a debtor, not initiated against the debtor, that there's a trustee involved who has statutory duty to look out for invalid claims, would all be equally true if the statement that the claim was, in the case of the statute of repose where the debt wasn't there at all. So I think while there are, what Thad said is accurate, there are other parts of the decision and other parts of the reasoning of the court that would also provide a basis for a defense to an FDCPA action. And, the opinion, one point the opinion didn't really get into, but, I think is also an important point here is, a proof of claim is not filed against a debtor. As a matter of bankruptcy law, a proof of claim is filed against a bankruptcy estate. And in a Chapter 13 case, a consumer debtor is required by statute to devote all of their projected disposable income over the life of the plan into the plan. And that number is what it is. And the amount of claims filed against the estate, except for the unusual case of the 100-cent plan, the claims against the estate don't affect the debtor's obligations. And so the person who's injured in the typical case, and we can talk for a second about failed plans, but hold those aside for this purpose. The person who's injured by an invalid claim are other valid creditors whose valid claims are diluted, not the consumer debtor. And the FDCPA is a statute whose history and purpose and text make clear it's about protecting consumers, not about protecting other creditors. So just from a purposive perspective, one could say invalid proofs of claim are just outside the scope of the problem the FDCPA was planning to deal with. And while it's true that you can hypothesize situations in which plans fail and the debtor's payments that they make go to pay debts that are invalid, these cases that are filed are not cases that are filed after the plan fails. They're cases that are filed while the Chapter 13 case is ongoing. And in those cases, I think there'd be a perfectly valid basis to say, listen, invalid claims that dilute the recovery of other unsecured creditors just isn't within the scope of what Congress was worried about when it passed the FDCPA. It's about people who can't protect themselves, and credit card companies and other creditors are perfectly capable of protecting themselves.
Okay, very well. Listen here, I'm going to have two more questions for you all before we wrap this thing up. Second, we're going to talk about the prospect of malpractice resulting from this decision. But first, Justice Sotomayor, in her dissent, made comments about how, in her view, debtors were worse off as a result of this opinion. Thad, I'd like for you, if you could, to, as briefly as you can, summarize what Justice Sotomayor said or meant when she said that debtors are worse off.
Let me count the ways. I think that they're worse off in just so many respects. First of all, they're worse off in that they risk revival of the debt. Most states where the statute of limitations is an affirmative defense and not an extinguishment of the debt provide for mechanisms for consumers to revive debts, either by making payment on those debts or by entering into some kind of an agreement, whether it be oral or in writing. And in some cases, it requires a combination of making a written agreement and making payment. But in any event, the payment of one of these time-barred claims by the trustee is A, payment on the debt, and B, pursuant to a writing by the debtor, i.e. the debtor's bankruptcy plan, which is in the 13, something the debtor must propose and have approved by the court. So effectively, the debtor is, cutting off its nose despite its face when it files a Chapter 13 bankruptcy, to the extent that it doesn't catch every single time-barred debt that gets filed in that case. Because it risks the potential of having those debts spring back to life in the very likely event the case fails. Similarly, debtors also are subject to debtors who pay 100% of their unsecured claims in bankruptcy, which for people that are making higher incomes is not all that infrequent, or people who have relatively low unsecured creditors pools, meaning very few claims that are not time-barred filed, or they have assets that they want to keep and have to pay the value of those assets to their unsecured creditors. Those debtors end up having to pay more if they are not successful in knocking out these claims. And in any event, those debtors have to pay their attorneys more if they have to review and object to claims that everybody involved in the process, and in particular the debt collectors, should have known and actually did know in the first place were invalid. And that's part of what we saw here is Midland, after the debtor objected to the claim, put up no fight. It let the claim objection be successful, and its claim was disallowed in the bankruptcy. So it knew. Otherwise, it would have, tried to insist that its claim was valid. And that's really part of the harm to consumers here.
Well, also, I've wondered whether the mere scheduling of a claim, particularly if it is scheduled as undisputed, might revivify the claim. But I tell you, folks, those are very thorny issues, which I suspect will be the subject of future litigation. I wish we had 2 or 3 hours to delve into them and try to resolve them, but I don't think we do. I would like to address the question of malpractice, because I'm wondering whether this decision opens up the possibility of malpractice either by a debtor's attorney or, for that matter, by a trustee who neglects to object to a time-barred claim. Do either of you have any thoughts on that subject?
Well, again, and I'm sorry if I'm taking up more time than I'm due, but as a debtor's attorney, I find that prospect terrifying, and I find it incredibly burdensome, because unlike the debt buyers who know and evaluate and value the portfolios of debts they collect based on whether the debts within them are subject to statute of limitations defenses, when a consumer walks into my office, I have no idea what debts are and are not subject to a statute of limitations. And aside from the debts that my clients are able to identify for me, and those debts that are still reported on the credit report, which typically only goes back 7 years, I can't know about all possible debts in that debtor's universe. And yet the failure to schedule and then to dispute based on a statute of limitations claim, I think could expose me to a malpractice claim. I think that the Chapter 13 trustees filed an amicus in opposition to the result here and in support of the consumer side, Johnson's side, saying, they have a lot of trouble, both practically speaking in reviewing the quantity of claims involved in bankruptcy, but also in legally speaking in determining what claims are and are not subject to statutes of limitations. So I think this opinion creates an awful lot of confusion and a massive burden on the bankruptcy system that didn't exist before it came down.
Well, in that regard, there was one of the circuit court opinions that found no violation of the FDCPA had a long section talking about how trustees have an obligation to object to claims, and they ought to get off of their whats and go and do it. On the other hand, I was told recently by a bankruptcy judge that trustees, Chapter 13 trustees, never object to claims. And furthermore, debtors' counsel don't object to claims unless it's a tax claim or a priority claim that has to be paid in full. Strikes me that something is slipping between the cracks here in terms of the realities of bankruptcy practice and the result in this case.
Yeah, so Bill, this is, I'm sorry, go ahead.
No, I was going to say I'm not laying blame anywhere. You cannot expect Congress to have dealt with every conceivable issue that might come up, because, this was a new industry, buying disputed claims or expired claims. This statute was written in what, 1970?
1978. Oh, the FDCPA, you mean?
Yeah, right. There was
77. Same Congress passed those laws.
Yeah.
I mean,
right.
Bill, in fairness, this is one of the many, many areas in which the Bankruptcy Code says what it says, but the bankruptcy practice is something of a crazy quilt of differing actual practices across the country. There certainly are Chapter 13 trustees who believe it's their duty to object to invalid claims. Indeed, the statute essentially says so. And there are Chapter 13 trustees who take that seriously and regularly object to time-barred claims. Others don't. It is true that the system we have for compensating Chapter 13 trustees doesn't pay them any more when they do that job well as opposed to not doing it at all, one can ask whether that system is properly suited to the purposes of the code. But it is true that there are many who don't. There are also, some number who do. And so I think that, that's an area that, can be looked at further as a matter of bankruptcy policy. There's nothing that stops a Chapter 13 trustee from filing these objections.
Well, you make a very valid point about policy, which is that this is an area that really ought to be examined by Congress, because I think what you're saying is the current economics of bankruptcy practice really do not enable either trustees or debtors counsel to object to claims at the minimal amount that trustees and debtors counsel are paid. And in fact, I think, Thad, you'll have to correct me about this if I'm wrong, but retention agreements for debtors counsel, I think, often do not require debtors counsel to object to claims. That's something additional that has to come out of a debtor's pocket.
I think that practice varies a little bit from jurisdiction to jurisdiction, and to Craig's point, he's right. There is a disuniformity of practice that is itself a symptom of the overall problem. But I think you're also right that the economics of consumer representation, or at least by and large, demand efficiency over thoroughness. And unfortunately, I think there are very few consumer debtor attorneys who are doing, fully scrutinizing every claim filed in every client's case, for better or worse.
Well, I got to tell you this. I frankly am never able to understand debtors counsel can do the enormous amount of work that is required in 7 and 13 cases for what they're paid. But I guess that's life. Congress and the courts can't solve every problem. Listen, folks, Thad, Craig, I thank you both very much for your participation in this webinar. If we have proven anything in this discussion over the last 45 minutes, it's that the Supreme Court, in my view, has opened a can of worms here, and the issues actually are going to multiply as a result of this decision. And consequently, perhaps we will also find other issues, such as these, winding their way to the Supreme Court in future years. But again, I thank our audience for dialing in, and I thank Thad and Craig for participation. And we will be with you again a day or two after the Supreme Court issues its third and last bankruptcy opinion later this term, which I'm suspecting will probably be sometime in mid to late June. So thank you all very much, and please tune in again the next time we are talking about the Supreme Court. Thank you and good day.